judging by what we've seen later when it's unredacted, has formed the basis of redactions requested by the prosecution, is that the prosecution take more time and care in identifying those matters that truly need to be redacted, and not the rather broad approach that they take at the moment, which of course leads to excessive time being spent by judges in having to assess the particular basis on which redactions are justified. So we are strongly opposed to it. We strongly support the judges continuing to have control of the redaction process. We consider that it's wholly in the interests of the accused that that process is maintained. Thank you, Madam President.
Thank you very much. Mr. Keegan-Cutwell?
Your Honors, the prosecution in their submissions have indicated that they would like to consult with the defense in respect to the reductions. On our part, in principle, we have no objection to consultations, and we have made that indication. That invitation of consultation should not be construed to be an admission of any aspect of the reductions until we consult and agree on the details. Secondly, we are strongly opposed to reductions being kept at the level that was adopted in the confirmation stage. We contend that it was too much and it went into the fundamentals of the case. Your Honors, we will pray that the standard adopted for purposes of reductions be applied in this case, being that every time the prosecution wants a reduction, they should justify it to Your Honors. And secondly, it should be determined on case-to-case basis. We say this because all the cases they have referred to relate to confirmation stage. And on that aspect, we wish to emphasize the fact that at confirmation stage, the standard of proof is very different from the standard of proof that applies to the main hearing. We also submit and pray that the court adopts all the decisions made at the hearing stage, being that the need for reductions be reviewed from time to time, and we submit that there is justification to hold the view that time has arisen for the need for the court to reconsider whether the reductions applied in the confirmation stage should still apply. Lastly, all the cases that have been relied on by the prosecution, we submit, as the Rutos team submitted, apply to issues of confirmation stage, not the main hearing, and that the prosecution's attempt has no precedent or support in law. Thank you, Your Honors.
Thank you very much. Prosecution, please.
Thank you, Your Honor. I will just make one or two points regarding our proposal for streamlining a system that's been very onerous on chambers in the past. And what we propose in our submission at paragraph 21, in fact, answers a lot of the concerns of the defense. What we propose is that the chamber first will rule on the categories of information that may generally be redacted prior to disclosure. And it's only when we have these rulings from the chamber that we'll apply them. And I just want to refresh my colleagues' recollection regarding the Katanga case. It is true that at pretrial, the single judge was reviewing all of the redaction process. However, at trial, Juge Scott accepted this inter partes process, and it was during the cross-examination of witness 250. It's at T105 in the English transcript, pages 3 and 4, lines 23. And at page 14, it goes on to line 6. So I think the reference there will show that the chamber, the trial chamber, had accepted this this approach to redactions. Thank you, Your Honor.
Thank you very much.
Question for Mr. Hooper. I'm trying to understand the extent of your objection to the proposal from the prosecution. Are you saying where there are some agreed criteria that the judges have reviewed and said, all right, redactions may be done on the basis of those criteria? And the prosecution takes a particular document and said, we are redacting on the basis of such criteria, and then supplies a log that indicates when they're done. Are you saying that's not good enough?
No, it's not good enough. Because one just has to think of the actual process. In fact, if we only look at some of the statements, or rather interviews, that have taken place in respect of witnesses served at the confirmation stage in this case, and look at the extent of the redactions in those which are being sought to be maintained, these aren't the occasional blobs of black ink redactions that we occasionally see. These are page after page after page. So what are we going to get? We'll get a document with extensive redactions. We'll look at it. And then we're going to get some criterion that's been exercised, allegedly, by the prosecution. And that criterion will be, for example, might be expressed as, may reveal the identity of the witness. I suspect very much we're going to end up with something rather bland like that. They won't be able to tell us often very much more than that. We just won't be in a position to judge it. What is the appropriate position here, and is the one that's been exercised here, with the exception of that Rule 77 statement that's just been referred to in relation to transcript 105, was in fact that the prosecution know the criterion that the court's looking to be applied. It's for them to apply it. They apply it to a document. They do it, we hope, with sufficient diligence and economy that it's not too extensive. They present that document, one assumes, to a judge in order for that judge to be able to determine whether, in his or her view, that degree of redaction is necessary. That's the appropriate process. I'm fearful that if we leave these criterion solely in the hands of the prosecutor with the very best will in the world, they will exceed the remit. As it is, we are confronted with statements that are so substantially redacted that we can only, of course, hope and expect judges, when it comes to this stage, will be scrutinizing those redactions in order to see them through the defense eyes and needs.
But I do not understand that the prosecution's proposal has the effect of leaving it all to the discretion of the prosecution to do the redaction as they please. The judges will still have supervisory role over it, in the sense that there may be instances where the system may work, and there may be instances where the defense may say, no, that's not good enough, let's go to the judges.
Yeah. Well, we've come often from different systems into this court, and from the defence point of view, we laud this system. We feel it's one that gives us confidence in redactions taking place. We've all been confronted by redactions in other courts that have been manifestly excessive and unnecessary. This is a particular restraint on the prosecution to impose what is, after all, an exceptional process. All the cases referring to redactions emphasise repeatedly the fact that it is an exceptional process. And it's an exceptional process that needs to be justified. So, for example, the Chamber may agree categories of information that may generally be redacted prior to disclosure. That's necessarily going to be, in our view, a rather bland definition, necessarily, because every statement's different, the content of it is different, and to get a general list of things, what is this list? Then the prosecution applies that criterion. Fine, that's the process we agree should take place and does take place. Now we say it's for the prosecution to show the judges what they've done and for the judges themselves to mark it as appropriate or not. That's the safeguard. Take that safeguard away, and what have we got? What we'll get is merely a redaction and some statement as to the basis for it. As I say, it may indicate or reveal or will indicate the identity of the witness. Well, I've seen cases where they've redacted the fact that 6 chickens were killed because that might have revealed the identity of the witness. We've got a case here with witnesses where they say they've attended meetings where the Honourable Ruto addressed people and said things he shouldn't have said. The date of the meeting, the place of the meeting is redacted. Why? Because it might identify the witness. So these are the kinds of things that need to be, at this stage, judicially reviewed. It's an active process. If there is a way to cut out the time that I know you, the judges, get inflicted upon in order to carry out this exercise, we'd warmly embrace it, so long as that judicial function remained. At the moment, it's being extracted. There's no doubt about that. It's being extracted and replaced by a general prescription of what the prosecution should do.
Thank you.
Thank you very much. Now, having listened to the submissions of rather extensive submissions of the parties, the Chamber would still like to extend another invitation for consultation, if I can borrow the wording of Mr. Kigen Katwa. The Chamber would like the parties and the registry to liaise in order, if possible, to find a middle ground or compromise or common ground or whatever for a reduction proposal. And this proposal ideally to be submitted for the Chamber's review by 3rd July of this year. Now, having dealt with disclosure and reduction issues, I think everyone in this courtroom became just a little bit wiser about the possible date of trial. Now, may I ask both parties that if they can be a little bit more specific as to a possible trial date starting from the prosecution in order just to conclude this part of the status conference?
Your Honor, the prosecution has no objection to starting after March 2013.
Thank you very much. Mr. Hooper.
We'd concur with that lack of objection, if I can put it like that. Mid-March or so of next year. And in respect of any written undertaking to attend, certainly no objection to that. But it would be unnecessary. Both the accused, as you know, voluntarily attended this court, both before any summons was issued, in the case of Mr. Ruto, and both, of course, afterwards for the initial appearance and subsequently, of course, for the week or so of confirmation hearing. They are, and given their word in any event, to abide by all rulings of the court, and particularly, of course, all rulings relating to attendance.
Thank you.
Your Honor, on the part of Mr. Sang, who is present in court, in the first instance, he is categorical that he has no objection to making the undertaking that the prosecution is asking for, an unqualified undertaking. Your Honors, on the issue of the date, we take notice of the fact that the prosecution say they will be able to complete their disclosure at the close of the first quarter of the next year. As submitted in our filing, we will request for a period after their complete disclosure to do our investigation and to prepare witnesses. And subject to that, Your Honors, we have no objection to a date being taken after March as suggested by prosecution. Thank you, Your Honors.
Thank you very much. Thank you very much. The Chamber plans to issue an order on the schedule for trial along with the relevant disclosure deadlines before the start of the summer recess. The next agenda item is languages to be used at trial. The prosecution and both defense teams have helpfully given an indication of the languages spoken by the witnesses that may testify at trial. One clarification for the prosecution. The prosecution mentions French as a language to be used during the trial. Is it because the prosecution intends to call French-speaking witnesses, or just because French is one of the working languages of the court?
Your Honor. At this stage, we don't have witnesses who are French speakers. French is one of the working languages of this trial section, and we may be addressing the court in French. Thank you.
Thank you very much.
But is it the case that every member of the prosecution team does speak English?
We all do speak English. Some of us express ourselves better in French than in English, and I happen to be one of them.
Thank you. May I ask the registry team how much time will be needed to provide translation and interpretation services for the languages indicated by the prosecution, which are Swahili, Kikuyu, and Kalenjin?
Good morning, Madam President. With regards to your question, the registry stresses that it's very important to know the exact number of witnesses and the specific language they speak, because it all depends on the language and the number of witnesses. For example, in Kalenjin or Luo or other rare languages, with all due respect, it's depending on the time of the mode of interpretation, either consecutive or simultaneous. There's no problem for simultaneous translation in Swahili or French and English, but for the other languages, it might be that it was consecutive, as it was in the Katanga case for Alur and other languages. But that consecutive interpretation adds about 30% to the time to the testimony of the witness, because it's not simultaneous, it's consecutive. Thank you. And we would need, I think, at least 3 to 4 months to goodly prepare before to provide the services.
Thank you very much for this indication. I ask, of course, the prosecution to liaise closely with the registry to ensure that all necessary preparations are made. And significant problems, of course, should be communicated to the chamber at an early stage.
With your permission.
Yes.
Your Honors, my client has a peculiar detail in respect to the translation, and I request for permission to make reference to it. Your Honors, my client belongs to the case against my client. His hint mainly on what he said to have communicated in a radio broadcast. That broadcast was made in Kalenjin, but we would like to emphasize, especially for purposes of the prosecution, for the purposes of the registry, that the Kalenjin has 10 subtribes, and my client is a Nandi, and that in the course of the registry's endeavors to get a translator, the fact of him having allegedly communicated do entail acquiring or procuring a person who speaks in the specific sub-dialect in Kalenjin of Nandi. Thank you, Your Honor.
Thank you very much. The defense for Mr. Sam has also requested in its written submission for the disclosure of the qualification of the interpreters, and also necessity of materials to be translated into English and an interpreter translator paid by the court to translate potential exhibit in advance. the defense for Mr. Sun should address these issues together with the point he just raised to the registry, please. And if there is any substantive questions which registry cannot deal with, maybe the registry can then address to the chamber.
We are most obliged to you, Honors.
The next item is objections to the conduct of the proceedings. The defense for Mr. Sun submits that it may raise preliminary issues under Rule 1342. May I ask the defense for Mr. Sun to be a little bit more specific as to these preliminary issues that you may raise?
Your Honors, pursuant to subsequent consultation and taking instructions, I have instructions to indicate to the Chamber that we have absolutely no issue to raise under that head.
Thank you very much. The next issue is legal recharacterization of facts. The prosecution submits that it intends to make an application for legal recharacterization of certain facts. Can you clarify, prosecution, what aspects of the confirmation decision do you have in mind? Is it something to do with contextual elements, crime or criminal responsibility?
The short answer is the individual criminal responsibility for the accused, Mr. Ruto. As Your Honors are well aware, Regulation 55.2 is a notice provision. And our application for the formal notice to be given to the parties and participants is what we're submitting today. Now, Regulation 55 notice is very different from amending the charges. And basically, Regulation 55.2 tells us that when there's a mere possibility that certain facts, that the legal characterization of certain facts may change, now when that possibility arises, then it triggers the Chamber's notice to the parties and participants of such. And prosecution's submission is that we are not changing our mode of liability that we argued in our document containing the charges and that have been confirmed by the confirmation decision. Our position has been and remains that indirect co-perpetration under Article 25(3)(a) is the proper legal characterization of Mr. Ruto's individual criminal responsibility. In fact, the pretrial chamber agreed with this position, and it remains unchanged. Now, what we would like to submit, and this is the basis of our application, is that indirect perpetration is not the sole legal theory that can be used to characterize Mr. Ruto's individual responsibility. In our view, the facts support that another form of individual criminal responsibility, such as 25(3)(d), could also apply. And because of that possibility, the notice requirement under Regulation 55.2 is triggered. This is, of course, totally different from an amendment of the charges. The counts that are pled in the DCC are the same, the facts are the same, and the mode of liability remains the same. So there's no alteration to the charges or the counts that we've already pled. In fact, we have complied with Regulation 52, which governs the requirements of the document containing the charges. So, in short, all we're doing here is arguing that there is a possibility that a different form of liability could be used in this case. And for that reason, when multiple legal characterizations are possible, then the Chamber must give notice of this fact to the parties and participants. Thank you, Your Honor.
Thank you very much.
Madam Prosecutor, you say that it's very different from, legal recharacterization is very different from the charges. But the fact that you can see a need for legal recharacterization so far ahead of the commencement of the trial, doesn't that tell you that maybe you might take another look at the charges? I'm not just asking a question. The reason I asked that is this. There are certain jurisdictions in which what you see with legal recharacterization here is not different from what happens in some places where in the course of the trial certain evidence has been called and the rules or the code of procedure, criminal procedure in those places would then permit an amendment of the indictment in order to make the indictment to conform with the evidence that has been laid in court. Is that very different from what we're looking at here?
It is indeed very different, Your Honor. In fact, we have pled 25(3)(d) in our summons application. The charges are the same. The facts are the same. And it's a very different situation because we're not substituting the facts or the mode of liability or the charges. And that's why this is very different from the amendment of an indictment at the ICTY, for instance. This is not a new charge. So, and just to sum up, what we're dealing with here is actually just a notice requirement for the Chamber when there's a mere possibility that legal characterization of facts may change. Thank you, Your Honor.
Thank you.
Judge Martin-Winkler.
Thank you, Prosecutor. My question is whether what you're asking us de facto doesn't amount to a request for alternative charges?
No, Your Honor, it isn't. And with your permission, we'd like to make a written submission to provide more details to the Chamber, if need be.
Thank you very much. The Chamber do appreciate the written submission. Do defense teams want to respond to this issue?
very briefly, it's interesting because in a way I think what the prosecution are doing is not putting us on notice but putting the Chamber on notice, because it's a Chamber's power to possibly alter the, as it were, crystallized substance of the confirmation decision. Our only concern is that in the prosecution's submissions for today's hearing, that they very appropriately raise this possibility, and we're grateful for that. And they say, in terms of their application, should there be one, because they'll be indirectly, of course, invoking the Chamber's power, it's not their authority or power, the application will be made well in advance of trial. And we would just like the Chamber to consider, in fact, determining what criterion should be applied there to express well in advance of trial. We would have thought at least 4 months would be realistic. Now, this may be, of course, tied in, and is tied in, with the matter that the Chamber's asked us to address and given us at the moment a deadline of the 25th of June, and that is to make submissions, the parties to make submissions on modes of liability. And we'd invite the Chamber to consider whether in the circumstances now it would not be more appropriate not to enter that discussion at the moment, but to delay it until one way or the other the prosecution have come themselves to a settled view as to what their position is in respect of that matter, because of course it directly concerns that. And as they're giving it deep thought, perhaps we can all save ourselves what would otherwise be a theoretical exercise, and instead, and again, within a proper distance of time before the trial, if the matter's raised, then we can fruitfully make submissions in respect of it. Thank you.
Are you saying to delay the submissions on the Article 24 order that the Chamber made until the prosecution would have done what he wants to do here? Or are you saying to delay the discussion regarding 25 now, today?
Yes, today. We have, at the moment, a deadline of making submissions in respect of modes of liability that arise under Article 25, and to submit those to the Chamber by the 25th of June. Given what's just been said, given that then if the prosecution begin to, as it were, draw this matter again to the Chamber's attention, for the Chamber to decide whether it would be appropriate to change the legal characterization, perhaps that would be a debate better reserved for that moment rather than next week.
Mr. Keegan-Cartwell?
Your Honours, on our part, we wish to notice, for avoidance of doubt, that the prosecution have highlighted that this issue will relate to the case against Mr. Ruto and not Mr. Sang. Secondly, Your Honours, it is our view that this is such a fundamental issue, much as it may not be directly on Mr. Sang's case. It affects us because it informs the date within which the trial may be conducted. And we pray that the court takes it into its hands and prescribe a time within which the prosecution is to make up its mind in two issues. The filing by the prosecution states in the second sentence that under Regulation 55(2) that certain facts may be subject to legal characterization. In the submission by the prosecution, they are also not being categorical whether they intend to seek recharacterization. And, Your Honours, we pray that the prosecution be obliged to make up their mind whether or not they intend to, and that a time frame be given to them within which to do well in advance of preparation for hearing, so that we all know what we are to encounter and prepare ourselves adequately for our defense. Thank you, Your Honors.
Thank you very much. Well, about the submission on this issue from the prosecution, can prosecution submit your written filing together with the one we asked on interpretation of law of the modes of individual criminal responsibility? The deadline is 25th June.
Regarding this issue, we've already approached the defense and have reached an agreement with the defense that because the issue of indirect co-perpetration is going to be addressed in the Katanga judgment, it is best to wait until the judgment is rendered for us to make our submission. And the defense on this issue is in agreement with us. Thank you.
Well, it is fortunate that we have one of Katanga judges here in this chamber. So the chamber will consider about the possible deadline and will communicate to the parties in due course.
Can I just add one caveat to that? We can see the sense of that, but it's still, whatever the decision might be, would be a decision of a trial chamber and would be subject to appeal by either side. And so to take this particular position logically to its conclusion, you'd have to add a little time element for one side or the other to exercise the point or readdress the point before the appeal chamber, which isn't the fastest operating appeal chamber. And so it's going to be perhaps it may be a difficulty. It depends on the timeline that you decide in terms of trial. Thank you.
Thank you very much. The next agenda item is post-confirmation document containing the charges. As you know, other trial chambers at this court have required the prosecution to file an updated post-confirmation document containing the charges, reflecting the charges as confirmed by the pretrial chamber. The chamber would like to hear submissions from the defense on this issue.
It didn't form part of our submissions of matters to be considered today, nor did it form part of the original Chamber's agenda. And I dare say that was because we all assumed, as we did, that the prosecution were going about this task in the light of the confirmation decision. There's a very good reason, of course, as we all know, why, in fact, the prosecution need to readdress their position and inform both the Chamber and, most significantly, the particular accused as to exactly what he faces and on what evidence in the light of the confirmation. It's particularly relevant in this case because of the way in which the confirmation chamber has made its decision and specified the charges. They've specified the I think it's 4 charges, but each one, in fact, breaks down into 3 particular crimes. So you've got 12 charges that need, in fact, enumerating 1 to 12 as far as Mr. Ruto is concerned, in order for those matters to be addressed in the course of the trial. That's the very simple issue. But the other issues involve, of course, the departure of one of the accused, originally or charged, suspects, Mr. Koski, and where that fits into the case. We've got the issue that's been raised today. We've got the fact that the prosecution do not know what witnesses they're going to call at the moment, and therefore, consequently, they don't know what the evidence that they're going to call. And, of course, while the facts can no longer be amended, as far as the confirmation charge is concerned, confirmation decision is concerned, that's crystallized the facts. The evidence in respect of the facts can be added to and altered. And so it becomes very important for the accused to know what he's faced with. So what we need is, I think in terms of the Katanga case, it became known as the summary of the charges. So we had a document, which was the document containing the charges, and then we got a document called the summary containing the charges. I don't need to review either the contents of that or the reasons, cogent reasons, that were provided for its need by the trial chamber. They're all set out, and you'll see it in the decision on the filing of a summary of the charges. In that case, it's filing 1547, and it's set out there. In that case, of course, we also had another document, which again seems to sail under various names, but essentially the name, I think, boils down to the in-depth analysis chart. To some extent, that the in-depth analysis chart has proved less useful. Ran, I think, to 1,300 pages in the Katanga case. Less useful because it's such a confusing point of reference. But on the other hand, it does have a utility inasmuch as it clearly gives the chamber the opportunity to see exactly the way in which the prosecution anchors its case in high detail. But it seems to us that the document, the new document to be called into existence, reflecting the confirmation decision and called the summary of the charges, is a document that should, in fact, in detail, indicate the prosecution case in such a way that all its evidence that it relies on is clearly related there to the charges, and in a way which is understandable to the individual accused himself, with assistance, of course, of his lawyers and advisers, and is a clear guide to the chamber as to what the prosecution case is. So, yes, absolutely essential tool for all the very good reasons that are provided by the various courts that have adopted that process. Thank you.
Thank you very much. Mr. Keegan-Cutwell?
Your Honours, on our part, we did not raise the issue of the document containing charges in our filings, and we also noticed that it was not referred to in the filings by the other parties, and it is because we also labored under the expectation that the prosecution would take the initiative of making the filing. We, on our part, in terms of proactively responding to the issue, wish to adopt the position that the court made in the case of Pemba, being that the filing should be made the final way in which the pretrial chamber has described them. Further, we pray that the detail of how the amended document containing charges should be lodged should conform, we submit, to the format that was suggested in the Bemba case, being to include footnotes and paragraphs of the confirmation decision. That's all, Your Honours.
Thank you very much. Prosecution, any view on this?
No, on the issue of the amended DCC, we share the position taken with the defense. We don't have any objections to citing the confirmation hearing when appropriate, and also citing when there may be a discrepancy between what the prosecution pleaded and what the pretrial chamber found in footnotes. I thank also my colleague from the defense, Mr. Hooper, who reminded us of what the in-depth analysis chart did not do, which was it did not, and I think it was in the chamber's view, did not really answer a lot of the concerns that both the defense and the chamber had at the time. It was a very voluminous document. It was very onerous on the prosecution, and it reflected, at the eve of trial, what was at pretrial. And clearly, at pre-confirmation, what witnesses state in their statements may vary from what they'll come and testify. And their testimony at trial is what will make the evidence of the record. Furthermore, the in-depth analysis chart had to be updated when lifting of redactions proceeded, which can only be done manually. Therefore, the chamber realized that the chart did not serve the purpose it was intended to originally serve, and with that in mind, requested the parties to present a summary of charges. So I just wanted to stress from the prosecution side that we do agree with the defense that the in-depth analysis chart did not serve the purpose it intended to and should not be relied upon. Thank you.
Thank you very much. As for the amended document containing the charges, if the chamber decides to request the submission of this document, when do you anticipate can submit that kind of document?
There again, I think there's an agreement from both sides. My colleague just mentioned the Bamba case, and I think in the Bamba case, the Chamber gave a month for the prosecution to submit such document, and we request the same time. Thank you, Your Honor.
Thank you very much. The Chamber will decide on this issue in due course.
Madam President, if I may, there is a matter which I had raised at the pre-trial proceedings about including in the charges other criminal conduct such as destruction of property, looting, and physical injuries. All the victims talk about this is what happened to them. If you look at the charges as drafted by the prosecution at the pre-trial stage, this conduct is not reflected as a specific charge. Now I think the time might be ripe to ask the prosecution, as they are now amending their charges, to charge. I see Your Honor shaking her head.
They're not amending the charges.
No.
They're just making a new document that reflects what has been confirmed by the pre-trial chamber. This trial chamber is seized by the decision of the pre-trial chamber, and it cannot go beyond the facts that have been accepted and confirmed by the pre-trial chamber. So we could not extend the charges.
No, that's precisely what I mean. These facts have been accepted by the pre-trial chamber. Because if you look at the decision, they make references to this conduct in no less than at least 20 times, and I can give you the page numbers which are written here. I don't want to take too much of your time. So this is what we would call the Regulation 55, where your chambers, your honors of your own initiative, can recharacterize these facts, because that is the evidence which is before the court. And not only that, the defense witnesses themselves came to court, and they all agreed that this conduct actually happened. It is actually even on an agreed basis. And my clients are very concerned that this additional conduct, or this conduct which has already been subject matter of the evidence, is specifically is referred to in the charges, because it will affect it at the reparation stage. Because the charges as set out now is only forcible transfer and persecution. This is a matter that the trial chamber, the pre-trial chamber, invited us to address, which we did at some length. But in the decision, there was no real mention of the submissions that we had made, other than to say that this conduct is pleaded. They also invited me to have consultations with the prosecution, whether they would amend their charges, and the prosecution said they're not going to do that. But I invite this chamber, under your power under Regulation 55, or any other power, to ensure that this criminal conduct, with the victims themselves say that they suffered on the ground, because it was not only forcible transfer or persecution, it was also looting, burning, and personal injuries. And I foreshadow perhaps an application in that regard. At the moment, things are not quite clear. I haven't been able to see my clients. But this is an issue that I had raised, and I think it was pertinent to bring it to your attention at this stage. Thank you, Rhoda.
Thank you very much, Mr. Anna. As Judge van den Wingeld rightly mentioned, the document we are now talking about is post-confirmation document containing the charges, which correctly reflect the confirmed charges and nothing more. But in any case, the Chamber will decide on this issue and will issue an order in due course, including its possible format and deadline. The next agenda item is definition of organizational policy. The defense of Mr. San submits that the parties should file written submission on the legal definition of organizational policy. Similarly, the defense for Mr. Uto submits that the definition of organizational policy should be indicated by the trial chamber at an early stage. Do you have any response to these arguments, prosecution?
Your Honors, Lucio Garcia for the prosecution in regards to this specific question. What the defense is basically asking the chamber in this case is to decide of the definition of organizational policy in a sort of vacuum, because we haven't started, obviously, the trial proper. So the prosecution's response in regards to these requests from the defense is that, respectfully submitted to the chamber, it isn't necessary at this stage for the parties to submit written applications regarding what is the definition of organizational policy. Now, as I've just mentioned, obviously there's this whole question of deciding, interpreting legal questions, and the prosecution is of the firm view that what it is when the chamber should decide these issues is during the trial proper, when considering the merits of the case, when there are facts to consider with and in regards to the legal question of what is or not, or if the prosecution has fulfilled its burden as to the question of organizational policy. Now, there's a second question as well, and it's probably something, and it's something that I feel emanates from the written submissions of the defense in this case, the fact that they're highlighting in a certain way that they could be prejudiced by the fact that the chamber does not decide on this matter before the start of the trial proper. Now, what the prosecution submits to the chamber in this regard is that there is no prejudice for the defense for the following reasons. This whole question of organizational policy has already been dealt with. It's already been dealt with by the pretrial chamber on its decision on Article 15 on the 31st of March 2010. Basically, in this decision, and I just make reference to paragraphs 83 and following, page 34, the pretrial chamber discussed at length what the definition of organizational policy would be, distinguishing obviously between organization and policy. There was a dissenting opinion as well. Afterwards, at the confirmation hearing itself, the chamber endorsed the definition that it had given of organizational policy on its decision on Article 15. So what the prosecution is saying, basically, Your Honors, is that this question has been canvassed already previously. The majority has decided on it. There is a definition which has been accepted already. So the defense is on notice as to what are the possible interpretations that can be given to this term. The defense has spoken about a liberal, expansive definition, and then there's this restrictive definition that has been spoken about and alluded to in the dissent of the judge. So basically, both positions have been canvassed in the past. The fact that the pretrial chamber has already decided on this matter on various occasions leads the prosecution to suggest and to submit to this chamber respectfully that it is absolutely not necessary at this point and at this stage of the proceedings, and we mustn't forget that the trial proper hasn't started, to decide on this matter in a vacuum. What the defense would have the chamber do, respectfully submitted, is to decide this question without the relevant facts that need to be taken into consideration, and to have the chamber fulfill a role which I would qualify as one of an advisorial nature, advising the specific defense teams on what the state of the law is. Both defense teams are represented by able defense lawyers who know the state of the law, and therefore written submissions on this matter at this point of the proceedings are not necessary. Respectfully submitted, Your Honors.
Thank you very much. Any response from the defense team?
Well, we're entirely in the Chamber's hands in respect of this matter. The pre-trial Chamber's definition was, of course, that non-state actors may be qualified as an organisation within Article 7.2a of the statute on the grounds that the organisation has the capability to perform acts which infringe on basic human values. That's the criterion that was applied. It was a criterion that was sharply dissented from by the third and dissenting judge, Judge Call. It was the argument advanced at the pre-trial chamber by this defence that the pre-trial chamber had adopted in error a new liberal interpretation of organisational policy, which was inconsistent with the intention of the drafters of the Rome Statute and inconsistent with customary international law. So there's the division. It's been a judicial division as well. And even though this point perhaps could have been dealt with recently in the appeal chamber, it wasn't. And so we're at the outset of a trial where organisation, its definition, is central to the case, and we have two differing interpretations of the criterion of that, and bearing the marked difference between the two, the defence merely sought to draw that to the attention of the chamber and to invite the chamber to consider whether it was a profitable exercise, vacuum or not, to consider the arguments there, which I suppose logically would have led, may by one side or the other, again have led to an appeal chamber consideration prior to trial. And it's entirely a matter for the chamber. Thank you.
Thank you very much.
On our part, Your Honor, we submit that, contrary to what the prosecution is saying, being that our motion and our request on this issue is in a vacuum, we submit that it is untrue that it is in a vacuum. We contend that the context and the circumstances of this case warrant the need to make that definition clear up front. We also submit that, unlike what the prosecution has said, the defense will suffer prejudice if that definition is not determined. We make this observation because up to the time the pretrial chamber made its decision, the definition of organizational policy was fairly clear and traditional, and the pretrial chamber was the first one to break off that consistent interpretation. Your Honors, we highlight the fact that the issue was so substantial that, number one, there was a dissent in the pretrial chamber in making a decision on that issue between the definition given by the majority in the pretrial chamber and the traditional definition given by the dissenting judge. We also submit that it was of such adequate magnitude that the appeal chamber elected not to determine it and to place it in your hands. And we pray that you take up the prescription by the appeal chamber and have that issue determined to enable us, as we submitted in our filing, to know the contours of the charges, to enable us to know the contours of the charges and to adequately prepare. We lastly submit, Your Honors, that the issue we have raised in respect to this issue is in all respects similar to the issues raised by the prosecution in terms of modes of liability And if they were to be entertained on their motion on modes of liability, then there is adequate merit to allow us to have this issue of organizational policy determined upfront. We thank you, Your Honors.
Thank you very much. Well, unfortunately, the tape is at the end, so we have to suspend now. So we will rise now and come back 11:30 to this same courtroom. Thank you very much.
All rise. We will adjourn.